Okay, we're here on ANDINA Inc. versus City of Panama City. Are both sides ready? You may proceed.
Good afternoon. May it please the Court. I am David Hawkins. I'm here on behalf of ANDINA and Columbus Rogers. And with me at council table is Andrew Byrne, who's also on brief. Mr. Byrne also appeared as co-counsel in the trial proceedings. And we'd like to reserve 3 minutes for rebuttal, during which time Mr. Byrne will continue our argument.
Okay, I'll try to remind you.
Thank you. This is an appeal of a non-final order from the Circuit Court that denied our motion for class certification. The case presents the most compelling illustration of why class certification exists, and that is when you've got illegal government activity and you've got the citizens who have had to submit to that activity, and but for the availability of class action could not have perfected their claim.
What was the class we were trying to certify here?
The class that we're trying to certify are individuals who receive final orders in connection with code enforcement proceedings that were issued by special magistrates who lacked the credentials of office. And it was during a finite period of time and issued by involving two specific individuals who were serving in the capacity of special magistrates.
Okay. The reason I ask
Go ahead, Judge.
is it seemed to me that both in your complaint and your motion to certify, you seem to be indicating that the class included those people that had liens placed on their property.
As a result of the final orders, the city's practice is to assess a penalty as well as record the final order as a lien against their property. So it accomplishes both of those. The city accomplished both of those through their final orders.
Would the city have been required to, or was that point specifically made that once the final order was entered, that it automatically became a lien?
I believe that's pursuant to the city's procedure. And as you read the final orders, you'll see where that specifically reserves at the bottom of the order language which says that this is self-executing essentially and imposes a lien on the property.
Okay. It seemed one of the concerns of the trial court during these hearings, and it was not specifically referred to in her order, was that there was no that she could not tell from the document that was in front of her whether liens had been placed on any of these properties, and that the witness really couldn't testify as to that.
I would concur with you that there isn't anything in the transcripts of the proceedings that shed light upon the analysis as to the existence or not of liens, but certainly the fact that the final orders that we put into evidence all have as part of the adjudication the assessment of fines as well as the recording of liens. And it was not a point of discussion, to my recollection, from the transcript.
Okay. Now, part of your argument, or part of the evidence that was presented to the trial court here, concerned a chart or a document, some kind of flow chart, that your witness had presented to the trial court. We do not have that in front of us, do we? You
have two spreadsheets that are in front of you. One of which is a spreadsheet which identifies 41 cases in which the two magistrates participated jointly in the cases. And the other is a spreadsheet which identifies a case name, a property owner, a case number, and a description of the activity that occurred with respect to those particular administrative actions.
Okay. There was an Appendix A or something to your brief, or Appendix 1?
That's correct.
And attached to that was I'll hold it up for something better by identification. It appears to be what was actually presented to the trial court?
That was one of the two spreadsheets that was indeed presented.
Okay, one of the two spreadsheets.
Yes, sir.
Okay. How many cases are reflected in the one that you booked for this court?
There are over 100 cases, but more telling to the analysis of the class action language in the rule itself is how many individual property owners were affected and how many final orders were issued with respect to those particular property owners. The evidence shows that there were 98 final orders issued by those two magistrates who lacked subject matter jurisdiction to enter the orders, and that those 98 orders affected over 120 property owners. That defines the class, the putative class, for purposes of our analysis.
But counsel, didn't the witness also admit that there were cases that for which the special magistrates had recused themselves, cases which did not result in final orders entered, cases that were never heard by the special magistrates, and thus the trial judge was conflicted, given conflicting information about the size of the class?
Well, to the extent that there was some ambiguity, if you will, in that first spreadsheet you showed me, then that was cleared up in the second hearing. The judge showed some concern in the first hearing in July that she was not satisfied that we had put on the kind of evidence that would give her a handle as to the identity and the number of property owners who were affected. At the continuation of the hearing in September, what we did was to introduce two separate files that are referred to as in green folders that comprised over 98 final orders. So laying the matter to rest, certainly to bring some closure to the issue as to how many property owners were affected.
Okay, do we have that in front of us?
You have a sample of that in, I believe it's Appendix L. Now, the documents themselves comprised almost 6 inches worth of documents, final orders. And taking the instruction of the appellate rules on preparing an appendix, as well as Judge Padovano's treatise, I relied upon the authorization that the appendix in this context is satisfied if we provide illustrations of documents which otherwise would be voluminous and duplicative. And so what I did was to provide a sample. Now, certainly we can provide the entire body if that's what you asked for, and that's not a problem for us to reach that.
Was a trial court ever presented with a single document that identified all of the property owners for whom final orders were entered and for whom liens were imposed?
There was never a single document, but there was testimony as to the identity of those individuals, or excuse me, as to the existence of those final orders, and a description as to how many orders were entered and how many individuals were affected by that. So we've got testimony at the second hearing where Mrs. Andrews testified that there were 98 orders culled from the 340 that the city had provided, 98 of which were final orders assessing liens and recording liens and assessing fines that affected over 120 property owners.
Okay, help me here a little bit, because you said the second hearing kind of cleared this up. And I've been looking at some of the testimony from that second hearing. This is an example on page 20. Let's look at Exhibit 1 for today. Would you agree with me, Mrs. Andrews, that number 1 here, listed on the first page, although it identifies 8 different hearings, that not all of those hearings involved the final order? That is correct. Then it goes on, and on page 21, and that's many pages, because every code enforcement case listed on here involved the entry of a final order. No. Page 22. Are you aware of how many of the cases listed on Exhibit 1 from today actually involve the entry of a lien versus a final order? No. So it's not entirely possible that many of these result in a final order but not in a lien. Yeah, I didn't list whether a lien was filed. That's correct. Isn't that competent substantial evidence or evidence to support a determination that you did not actually prove the number of people potentially in the class?
I would disagree with that and suggest that the evidence is much stronger by looking at the final orders themselves. Those indeed were put into the record. The testimony I believe you're referring to was Mrs. Andrews being examined once again as to the spreadsheet that she prepared in connection with the first hearing, the phase of the hearing that began in July, wherein she had taken information from city minutes, from orders that were entered of non-final nature in connection with code enforcement cases, as well as final orders, culled them together, put them into a spreadsheet to identify them. They were not intended to be the exclusive exposition of final orders.
Okay, where can I look in the record that we have in front of us and determine whether a lien has been filed in a particular case?
You cannot identify whether a lien has been filed unless you look to the final order, and there's only a sample of final orders that are included in the appendix filed here.
Counsel, it seems to me this was the second hearing on the motion for class certification before this court, and clearly there were some questions that the trial court had at the first hearing about the definition of the class. Wouldn't it have been prudent and easier to bring together a spreadsheet listing exactly those plaintiffs who were putative members of the class?
It could have been, but the best evidence, as I've indicated in our brief, is certainly the final orders themselves. And her coupled with her testimony elaborating as to the number of those individual property owners who were affected is the best evidence of numerosity in this case. And may have been helpful to underscore the document itself. It was a composite exhibit, for us to have also done another spreadsheet. I don't disagree with that. But coupled with her testimony explaining how many people were affected was precisely the points on which we rely to show that numerosity was established.
Okay, part of my problem with what I'm looking at here, and you've done about 4 minutes now, it's the spreadsheet I'm looking at, and it talks about the Raymond Wahlberg property and on 1900 block of Frankfurt Avenue. Almost every one of those entries talks about reserved jurisdiction, hearing officer reserves the right to take any further action deemed necessary. None of these say that a specific order resulting in a lien is taking place.
And I don't think that that's a dispositive point on our behalf as well. And for the very reason that at the time the hearing resumed in September, we corrected that aspect of the case. To the extent it was a deficiency, we laid in front of the court a composite exhibit of all the final orders that we had culled from city records that resulted in assessment of liens and the recording of liens and assessment of fines against the property owners during that period when those individual jurists, lacked credentials of office.
You're down to about 3 minutes.
Okay. There are a number of problems we've identified with respect to the final order itself. The first one I'd like to talk about is in paragraph 15. It said there's no formal indication that any party other than those named in the complaint is pursuing legal recourse. We believe that this is a misstatement of the law, certainly as to a fair reading of 1.220. There is no requirement in there that the plaintiffs have to identify the names of the individuals of the putative class, nor is there an obligation that we have to go out and solicit people to join as parties to the lawsuit. And indeed, this is completely contrary to the procedure set out in 1.220.
Okay, I'm focusing on paragraph 15 because I think you raise a legitimate concern here. That paragraph can be read to say that the only people that she was going to allow as a party, or the judge was going to allow as a party, are those people that were going to pursue formal action. Could that paragraph also not be read to say those are the only people that you sufficiently identified who have a final judgment or a lien against their property?
I would say that that's totally inconsistent. That's a misreading of the rule as well as the case law construing the rule. The case that we cited in our brief, Holly versus City of Naples, is right on point, and I would encourage you to read that. I can recite what happened there, but essentially, very briefly, there an individual received a parking violation from the City of Naples, $2. He wanted restitution. Then he realized that the City of Naples had its municipal court abolished back in 1973. This was a ticket that he received in 1977, so he filed a class action. The circuit judge denied his class because The city came forward and argued that we don't know the identity of the individuals who received parking tickets. Therefore, you can't ascertain their identity nor comply with the requirements of pleading. The district court reversed. The second DCA said, as long as you've got an identifiable class with issues that are understandable, then we believe that the obligation of the plaintiff in a class action lawsuit has been satisfied. We don't have to identify by name the individuals. We simply have to bring forward and put into evidence the number of individuals that were affected, and that obligation is satisfied by the final orders that we have in evidence.
Okay. Let me clarify something. I thought you said Mr. Byrne was going to take some of your time?
Yes, he is, at rebuttal.
Well, you got it into your rebuttal time. You've got used it up. Mr. Byrne, I don't want you to feel bad about coming here and not being able to talk, so we will give you 2 minutes for rebuttal, add 2 minutes to the city side.
Thank you. Much appreciated, Your Honor.
Good afternoon, Your Honors. May it please the Court, my name is Hallie Stark. I'm the attorney for the City of Panama City, here on the order denying class certification entered by Judge Costello in Bay County. There's a few points I'd like to submit preliminarily. The first one being that the standard review here, I know this has been somewhat contested in the appellant's brief, is firmly within the abuse of discretion. There is not a single case that would say that a determination of class requirements is anything but a factual finding which falls within the discretion of the court.
Okay, but help me here, and it revolves around paragraph 15. Let me ask a preliminary question, and I'll ask you about that paragraph. Would you agree that if the trial judge ruled that in order to establish a class of people, that you had to show those people that are actually ready to pursue legal recourse, that would be the wrong standard for a potential class in a class action?
Well, I would read it the same way you did before, that those are the people who actually... Okay,
we'll get to what it says. Okay. But I'm asking you whether you agree with me that if the trial court ruled, or the ruling could be read, well, not could be read, if any trial court rules that in order to establish a class action, that to demonstrate the number of the people in the class, that you have to show that those parties are ready to actually pursue legal recourse, that would be wrong, legally wrong. I'm out there on a hypothetical now.
On a hypothetical matter, I would submit that it could be possibly harmless error depending on the actual allegations and facts and the class definition that belie what the determination is that the trial court's making.
Well, let's bring it a little bit closer to this case. If they had clearly come in and shown that all these people had a lien filed against their property, would they additionally have been required to show that those people were interested in pursuing legal action?
I think that is somewhat relevant, although it may not be dispositive of the issue. I mean, the putative class, I understand it to be that those are people who are out there.
Or potential plaintiffs. I mean,
right.
The putative class, we're talking about potential plaintiffs, not those people that have actually expressed an interest in filing the case.
Right. Well, and that would leave us back at two plaintiffs where we are now. That's where we've stood. And maybe that's a little bit of confusion that's in the trial court's order, but I read it the other way, which is just to say that the people who are identified as plaintiffs at this time are the only ones who have submitted any competent substantial evidence, if even them. But the trial court is supposed to look beyond the pleadings when there are issues that are legal in nature or where a determination of defenses and claims will be necessary to evaluate and make a proper determination on the propriety of the class as a whole.
Okay, they said they submitted a number of orders in front of the trial court.
Yes, they did, Your Honor. They submitted at the first hearing, I think it was, 360 orders of all different various stages of the proceedings. and the sample of that spreadsheet that's attached as Appendix I, which, as you can see, it did not identify any final orders.
How about the orders submitted at the second hearing?
Now, I'm not too sure what they're talking about with the orders at the second hearing. I'm aware of the citations being submitted as well as the secondary spreadsheet that showed the 41 commingled cases that were presented still without final orders. Notwithstanding that, even if those orders were
Okay,
submitted.
it was represented, unless I misunderstood, that there were final orders submitted at that second hearing.
I don't know if that's a misstatement or if that's a misunderstanding on my part, but I know that the 360 orders were at the first one, and they were of all various stages of the proceeding. So, but even if the 98 or however many they now claim exist, that still requires the numerosity examination, which is twofold. And the first part of that is an inquiry into the class definition. And here there's a legal issue intertwined that can't be removed from the class as defined. And that's not just about the orders, which were not shown on any of the final orders none were shown on any of the spreadsheets that were submitted. It's the issue of whether a special magistrate was unappointed at the time. And that's a matter of law that would have to be established at a later time. Regardless of how many orders are proffered, if we assume that all the orders were brought in and that they had gone through one by one and properly introduced it like they're supposed to in Vega, not just testify to numbers, but actually talk about who's out there and identify the class, then we still get to the issue of was that order entered, well, first of all, who was it entered by? And secondly, was that person unauthorized or unappointed at the time that they entered into it? It's very possible, and the city has contended consistently, that all orders that were entered by Dingus are to be upheld. The ones by Hunter have been vacated. So what we're left with right now, I mean, it is two different claims almost, because you have, depending on, when you read the definition, it relies on an unauthorized or an unappointed ruling by Special Magistrate Hunter or Dingus. And if you have one, that goes to the merits. That's a legal determination that although the appellants will argue and have argued that the merits were reached or that legal conclusions were made as far as the claims of the class, that's not true, because that is something that would completely undermine what it is that they have stated, as well as the claims that are actually brought in the second amended complaint that you noted earlier about the fraudulent lien statute and the slander of title, which there are issues that go to that as well. And these are all things that need to be considered, but right now, all the trial court ruled on was a very narrow issue, which was numerosity. Have the plaintiff showed up and provided competent substantial evidence that a numerous class exists as provided by 1.220 or Rule 23, either or. Either one, it's the same provision. And the answer is no. What they have provided is this moving target, where we started off with hundreds of plaintiffs, and then 122 interrogatory says there are 3. Then we get to the testimony of Ingrid Andrews, who, despite the fact that her counsel had previously represented the court 128 that same day in September, she said that she was aware of 7, to which it was countered by counsel, that we have 2 here today and several waiting in the wings. You can't make a determination based on competent substantial evidence or any sort of factual finding and it not be an abuse of discretion. I mean, it would have been an abuse of discretion for the trial court to have found that numerosity existed given the spectrum of claims that have been made. You don't earn a right to or entitlement to class certification, if you will, just by saying that you have a class. And that's consistently held.
Let me rephrase what you said, because I'm going to pose this to the other side. Mm-hmm. Even if we read paragraph 15 to set out the wrong legal standard, and I know you don't agree with that, but if we read it that way, as I interpret your argument, we could still affirm this case because there was no CSE to prove numerosity, even if the trial court utilized the right standard.
Right. I mean, there's no way to get to numerosity based on what was presented. It was never the city's responsibility to prove that a class didn't exist. And when a class is disputed, the burden is absolutely 100% on the plaintiff to establish through competent substantial evidence that one does exist. And we have contested literally every element of this class action, every claim therein, with the exception of the attorneys being capable of representation. But everything else that's in there, we have contested in one form or another, and that's reflected in the trial court's order and even the briefs and some of the memos that are attached in there.
Counsel, can you respond to the argument that the final orders themselves constitute competent substantial evidence that there were sufficient numbers of class members to satisfy the rule?
No, I would not, Your Honor, based on the case that they've cited, which is Vega versus T-Mobile, in which they were seeking to establish a class based on, I think, lost sales commissions or something to that effect. And they had an HR representative from, assumably T-Mobile, come up, and she testified, we have 6,000 sales representatives. The court held that's not enough. It's not just a number. There's no numerosity with just the testimony of a number that's out there, because there must be some means to support a factual finding. And that's what they held. They also held that while the determination of merits is not required at the certification stage, the court should consider the merits to the degree necessary to determine if the class requirements were met. So irrespective of whether the orders were entered or not, if you're going to start looking just beyond the number, you see that the class definition, which is inherently a part of the first element of numerosity, it hasn't been proven. It hasn't even been attacked. It hasn't been countered. Nothing. So absent showing that there was that the special magistrates were not appointed or were otherwise unauthorized when contested by the city, it still fails. So it's a kind of a roundabout way back to the same place that we started, which is that there was no competent substantial evidence of numerosity on really any front. And it was not an abuse of discretion for the trial court to find when the appellants are presenting varying claims and the numbers are changing with every pleading, that there needs to be more than just a statement.
Okay, if we have 40 orders entered by
Dingus or Hunter, right?
40 orders entered by Hunter.
Uh-huh.
And those orders that are presented are clearly final orders. Assessing the fine. I assume the Panama City Code has something in there that they could be filed. Chapter 162 indicates that they can be filed. If we do, in fact, have those orders in front of us, would that not be sufficient to demonstrate numerosity for either one or both of those magistrates?
Well, for fines, no, I don't believe so, because this deals with slander of title and fraudulent lien under the construction lien statute. But if it actually imposed a lien and not just purported to impose a lien, then perhaps a full showing would have, at a minimum, met the evidentiary standard of just hitting numerosity, not addressing the legal issue that is intertwined within the class definition. Yes. But that's not what was presented. What was presented was a document that made no indication of any of the claims that would be necessary to maintain this lawsuit. No final orders were noted. It didn't distinguish who entered the final order, if one was entered, whether it ever reached a final adjudication. Some things were listed 8 times. And what happens is it creates the appearance of a much larger class than what's actually there. So I would absolutely argue that the trial court does need to go beyond just looking at the numbers or just looking at a piece of paper to really evaluate it when you've got a document that just in looking at it you can see that it's much larger than what it needs to be. If it purports to be 41 final orders, which it doesn't, but if it just addressed the 41 orders like in your hypothetical situation that you just posed, well, that would be a very different case than what we have here. Well, I would just respectfully urge this court, on behalf of the City of Panama City, to affirm the lower court's ruling and not find that an abuse of discretion has been made. The decision was reasonable. There have been no allegations that it was anything but reasonable. And same thing with the form. The appellants have not contested the form of it. It is compliant with Rule 1.220 as far as having findings of facts and conclusions of law. And absent any sort of dispute that this is an abuse of discretion or allegations that the judge acted unreasonably or is not in the best position to carefully weigh the evidence being there, then I don't think that an abuse of discretion finding would be proper under the circumstances, and so I would just request that you affirm it.
Thank you.
Thank you.
Thank you for the 2 minutes.
Okay, well, I'm going to give you 2 minutes and 15 seconds because I'm going to ask you a question to start off.
Yes, sir.
Tell me where I can go. When I go back in, with Judge Roberts and Judge Rowe, we go back in and look at this case, tell me specifically in the documents in front of us where I need to look to determine how many final orders there are, how many liens have been filed, tell me specifically what I need to look at.
Okay. You need to look at Exhibit 3 from the September hearing. Now, it does require some explanation. In the first hearing, we had received hundreds of thousands of pages of documents, which were, in fact, orders entered by these special magistrates at these proceedings at a time when they weren't credentialized. So we got all these documents. Now, as you can imagine, code enforcement hearings aren't handled with the same formality as a circuit court hearing. So you have various orders affecting people's property so that they would be hailed into court. They'd be told, you're going to spend this amount of money to fix this, and you can come back in 30 days and show me that you've spent the money, and then I might dismiss the case. They're still affected by an order. When that citation...
Okay, you say they were affected by the order.
That's right.
And I understand your argument that might have been your class, those people that had orders entered against them.
Correct.
But if you read your complaint and your motion for certification, they talk about those people that have their titles that have been slandered.
Well, and in fact, and I can clear that up too, when the citation issues, the very first document, when the police officer goes out to the property, that citation becomes a lien against not just the property that's affected, but all of the property by the person until the case is completely adjudicated and the fines have been paid. That's how it works in Panama City. So if I am XYZ homeowner and the Panama City Police Department comes out and says, we're issuing you a citation for tearing up protected trees, that citation from that moment is recorded and it becomes a lien against all of my real property and personal property for that matter. So that, for example, in Columbus Rogers' case, he had 3 or 4 different parcels of property. And it is in the record that when he sold one, he had to pay $21,000 because of a lien against another parcel. So Exhibit 3 was, Your Honor, to answer your question, we had over 300 orders which only affected, we had conceded, 122 cases, okay, because there were multiple orders entered sometimes on cases. What we did at the hearing was we took Ms. Andrews went through all of those orders, and she prepared a summary, which is not evidence, of course. It's a summary of documents. And that was Exhibit I that is in the appendix. It's just a sample of it. And she testified at length about the at least 122 cases and 90-something parcels of property. Then, at the second hearing, because the court was concerned.
Your time's run, but let me just make sure. The Exhibit 3 you're talking about, that was Exhibit 3 of the hearing?
Yes, sir.
Okay, was that brought in front of this court?
It was admitted into evidence. It is part of the record. It was not elevated. I understand it was not elevated from the trial because it's so big. Instead, we attached in an appendix a sample of what was from that, and that is Appendix L, where we attach samples of those documents, but they are in the record. They were introduced into evidence, but because of the size, literally boxes like this, I don't believe they were elevated to the court. In addition, Ms. Andrews testified from reviewing all of those, and it came in without any objection as to the number of properties and the number of people affected. And the point was,
I'm going to give you 30 seconds.
The identity of all of those people who had their properties affected by what we maintain as illegal code enforcement officers are all in the city's records. And so when they were produced to us and testified without any objection whatsoever, in summary fashion to make it easier for the trial court, no one ever objected. But when there was a concern raised that there might be an error in our summary, which we maintain they never showed us any error, but we introduced every one of the orders into evidence so that the trial court could do the following. Take our summary, and if she wanted to, look at every one of the 300 orders and see that there was at least 122 people affected as we testified without objection.
Okay. Giving you 30 seconds. Thank you.
Thank you, Your Honor.
The next case in front of us